Hello and welcome to this UK IBC webinar on the UK Bribery Act, featuring our strategic partner, PwC. My name is Adriana Vega, Policy and Research Manager here at the UK India Business Council, and I will be your moderator today. Corruption is often quoted as a challenge in India, sometimes expected and sometimes real. However, many businesses do manage to operate there successfully and in full compliance with the law. So today, our speakers will discuss the operational environment in India and tips on how to manage your risks 3 years since the UK Bribery Act came into force. Just before we begin, I would like to familiarize you with the toolbox on the right-hand side of your screen. Just to let you know, we will have everyone on mute during the course of the webinar to keep any background noise to a minimum. But if you have a question, please drop it into the little bracket on the toolbox to your right in the Please Type Your Question Here box. And that will send me your question. I will take it up during the Q&A session at the end. For now, to make sure that you can all hear me clearly, can I please ask that you all use the Raise Your Hand button on the toolbar? Could you please click the Raise Your Hand button? Okay, thank you. Now, I would like to introduce our expert group of panelists. From PwC India, we welcome Gagan Puri, partner, and Rahul Lalit, associate director, who will discuss the Indian landscape. Also speaking today are Will Kenyon, partner, and Keith McCarthy, director, both of whom are based here in the UK, and they will tell us more about the UK anti-bribery landscape and recent trends. So without anything further, over to you, Gagan. Thank you.
Thank you, Adriana. Thank you, Adrian, and good morning or good afternoon to you all. As you may have known or may have heard, we call India a land of contradictions, home to over 1.2 billion people, which constitutes about 17% of the global population, but actually India occupies only about 2.5% of the global landmass. A leading provider of brain capital, a large contributor to the pool of global doctors, global engineers, professors, but a country where 36% of the adult population still cannot read or write. Historically, India has been a global center of learning with some of the earliest known universities established in India, but still a country with a school dropout rate of over 40% at elementary levels. India is considered a leading provider of global services such as offshoring, information technology, ITES, but yet 1/3 of the rural population in India still does not have access to electricity, and 17.5% of the schools do not have access to drinking water. Many of you would have been following India's story over the last couple of decades. We had a period of economic liberalization that started in 1993. This was followed by a great period of economic growth with sustained positive GDP growth year on year. We barely scraped through the global meltdown in the late to mid 2000s, struggled a lot in the past 5 years due to various factors, some of which have included very slow policy reform with government and various sectors unwilling to open up to investment, lack of clarity in policies. Businesses have often said India is fraught with procedural difficulties in doing operations. Bribery and corruption over the last couple of years has been a major issue, with India being hit by one scam after another. But the fundamentals of the Indian economy continue to remain strong. You cannot ignore a vibrant, growing population of over 1.2 billion. And there is a whole ton of opportunities for companies looking to expand their operations, given the large population base India has. There have been some recent very positive changes in the regime in India. There's a new government that's come in. Clearly, there's a lot of buoyancy in the Indian market, where there is a felt need and a perception that reform agenda will come back on track. And businesses are quite optimistic that the much-needed reforms will come through. And lastly, a lot more positive changes are expected on the regulatory side. We will talk about some of them today, and some of them you will see in the coming years, hopefully, in India. Can we move to the next slide, please? Slide 6. So what really makes doing business in India challenging? We speak to a number of companies that do operations in India, and we ask them routinely what are the challenges they face. And the slide actually lists down some of the major areas, but top of the line, whenever we talk to people, the first issue that comes up is regulatory compliance. and India's vast and extensive plethora of laws and regulations. Just for an example, a retail business looking to set up a single outlet may need anything more than 40 to 45 licenses to get its operations up and running for every single outlet they run. And to add complexity, our entire regime of laws related to operation is changing. You know, we have a new Companies Act that's come in. Clearly, it will be tried out in the next couple of years. It poses a number of obligations on companies which are different from what we had in the past. There's a new GST Act, a Goods and Services Tax Act on the annual that will impact the entire regime of indirect taxation. We have talks of a new direct tax code that is being planned to completely overhaul the direct tax law environment. So really when you look at a company, the basic company law, the direct tax law, the indirect tax law, everything is kind of set to change. So new laws, new interpretation challenges, lack of enforcement of the laws we already have, and policy changes all create an environment that businesses routinely say concerns them when they talk about India. The second aspect people say is, you know, the conduct of business, and it's difficult to do business in India. And one of the main things that comes up when we talk about a bribery and corruption perspective is companies often tell us that there's a lack of a level playing field. Foreign businesses, because of regulations in their home countries, which may have at times stringent laws and stringent enforcement, but there's the perception that, you know, business in India don't need to comply with those. So really it creates an unequal playing field whenever you talk about competition. Most common areas that people see these challenges are tax compliance, health and safety laws, and more importantly, bribery and corruption. You know, from an India perspective, it is not as if laws in India are different. They're probably as stringent as laws are there in other countries. The difference probably lies in enforcement. When you really look at the enforcement regime in India, the government departments are often understaffed. They may not necessarily have the skill sets to really enforce laws effectively, and there could be, and there is corruption at local levels. You'll be surprised to know that only this month, the government of India actually banned the use of Gmails and Hotmails, because over the last 10 years or so, a lot of government departments don't even have email infrastructure, and they're using these streaming email IDs to communicate on official channels. So really, you know, the pace of infrastructure has also not kept pace with the way business is transacted. The third area people talk about is cultural issues. Indian promoters at many times have a different mindset. Especially when companies say they hire people from promoters into multinational companies, there is a risk of bringing over practices that could cause problems for them. You know, and I'll give you an example. I was recently called by a so-called association, which told me over the phone that we formed a cartel and we need someone to come in and audit the cartel. Now, with the fundamental premise that cartels are unlawed in India, but the whole fact that they didn't seem to think anything was wrong in forming a cartel and doing operations, and they felt that they could get a cartel audited, was, you know, kind of a surprise to us. A number of times, you know, we do get calls saying, well, there's embezzlement in companies, and when we start looking at some of these issues, it's actually in the creation of slush funds. And it's hard for people at times to grapple that, well, it was wrong to create a slush fund in the first place, let alone an embezzlement happening from the very slush funds you created. And lastly, bribery and corruption. I think in a country where the law states that giving anything of value to a government official is a violation of the anti-bribery laws, I think the tone is very clearly set in terms of what the intent of the law is. In practice, reality is quite different. We see it in three forms. The first is requests and solicitations. It is not uncommon for businesses to be asked for small bribes, petty, you know, requests for, you know, what seemingly appear to be routine transactions. But really, once companies give way to these solicitations, it's a, you know, kind of a situation from which it is very difficult to turn back. And then the number of solicitations and requests keep going up. The second is economic extortion. To give you a quick example, we had a client where they got a call saying, well, we want, you know, why don't you pay X amount of money to a party fund? The client refused, and the next day there was a 6 foot deep, 8 feet wide trench dug on all 4 corners of their factory with their connection to electricity, water, and sewerage disconnected. So that's kind of economic extortion, saying if you don't pay, this is what could kind of happen to you. And the last, we do see some forms of this is physical extortion also. While some can argue that, you know, physical extortion is kind of maybe under some laws, you know, something that companies can deal with, but under Indian law, again, giving anything of value to a government officer is a crime. And one quick example I can give you is a CEO of a company who was detained overnight at a police station, and which may not be the most pleasant experience for anyone to be in, but this was purely on account of a check dishonor case, which believe it or not, in certain cases, a criminal offense in India, and you can be held by the cops for it. And there was a request for a bribe to let him go home. But it is again, this is where physical extortion and physical threats come in. With that, I hand over to my colleague Will to talk about the UK anti-bribery and corruption landscape.
Thank you very much. Thank you very much, Gagan. And against that backdrop of the sort of the cultural and business landscape in India, I thought it'd be helpful to just remind ourselves of the basics of the UK Bribery Act, which of course affects any UK national and or UK registered company attempting to do business in India or indeed elsewhere in the world, and will also potentially catch Indian companies with business connections with the UK. So the UK Bribery Act came into force on the 1st of July 2011. Therefore, it's been in operation for over 3 years now. And we'll look at what we've learned from early experiences in due course. But just in terms of what the Act contains, there are basically 4 offences. There are 2 general offences: active bribery, that's paying bribes, and passive bribery, receiving bribes. A bribe in that context is defined as giving something of value in order to induce improper performance of a relevant function, which in simple terms is if you're trying to get somebody to do something that they shouldn't do in any kind of official capacity. It's important to recall that those general offences cover both the bribery of government officials of any kind, public officials, but also bribery purely in the private sector, so it's sometimes called commercial bribery. There is a separate offence from a UK perspective of bribery of a foreign public official. So any public official in India will be a foreign public official from the point of view of the UK Bribery Act, of course. The reason for that separate offence is that the test of what is bribery is somewhat differently defined. So in that case, we're talking about offering a bribe in order to influence a foreign public official in order to gain or retain business or an advantage in the conduct of business. So you can see that the improper performance test is not present in the same way, and I think practically speaking it's designed to be rather easier for prosecutors to prosecute overseas corruption. Last but very much not least, there is then a corporate offence of failure to prevent bribery. So this is directed at companies, not at individuals as such. The offence consisting of effectively a predicate offence of bribery by an associated person, that's an employee, subsidiary, agent, or anybody else doing anything on behalf of the company in question. If that occurs, then the company could be prosecuted for failing to prevent such bribery. As we'll come on to later, there is a whole defence to that charge of if the company can demonstrate that it had adequate procedures in place to prevent such behaviour. That's the basic outline. The jurisdictional reach is an area which is still open to interpretation, but as I mentioned, any UK company, any UK national, any national of any country who is resident in the UK, and anybody who does something physically in the UK that is connected with a bribery offence, all of those will be caught. Foreign companies may be caught if they do business or part of a business in the UK, and that is one of the aspects that is yet to be fully tested. I think the penalties speak for themselves, in particular from a corporate perspective, the prospect of unlimited fines, debarment from public procurement, and obvious reputational damage and the wider collateral damage that might ensue ought to be motivation enough to try and get one's house in order. So those are the basics of the Bribery Act. We will come on later to discuss the concept of adequate procedures and what that means practically for businesses. But for the moment, if I can hand over to my colleague here in the UK, Keith McCarthy, just to talk to us a little bit more about the law enforcement regime here and recent trends that we're seeing in law enforcement around bribery offences.
Thank you, Will. On the back of the Bribery Act, the UK needed to introduce an effective mechanism that would provide prosecutors with a tool for combating serious economic crime committed by commercial organisations. The process of corporate plea negotiations were difficult in the UK context, particularly when having to consider the controlling mind principle, and there had been significant judicial criticism around the outcome of corporate settlement negotiations. Consequently, legislation dealing with deferred prosecution agreements, commonly known as DPAs, was introduced within the Crime and Court Act 2013 and became effective from the 24th of February this year. Essentially, the legislation enables the Director of the Public Prosecutions and the Director of the Serious Fraud Office to invite corporates only to negotiate a DPA. Importantly, DPAs are not a rite of passage for any corporate that discloses wrongdoing, and consequently the considerations for both the corporate discovering the wrongdoing and the prosecutor in considering the facts and the evidence presented are very significant and should be dealt with transparently at all stages. The SFO have been clear that their role is to prosecute serious, complex fraud, bribery or corruption, and disclosures to them by corporates will be considered in accordance with the Code for Crown Prosecutors, looking at the evidence and the public interest. They have been clear that a DPA might be appropriate where the public interest is not best served by mounting a prosecution. The mechanics around when the prosecutor might consider it appropriate to offer to negotiate a DPA and what would be expected from the corporate was set out within a code of practice issued by the prosecutors earlier this year. Without doubt, whether to self-disclose remains one of the most challenging questions for organisations and its advisors alike. The incentive for the corporate to self-disclose currently looks weak given the UK prosecutors' statements around prosecution, but on the other hand, the consequences of not disclosing or even disclosing in a partial fashion are severe, and with the introduction of the sentencing guidelines next month, corporates in the UK can be fined as much as 400% of the value of the gain from the organisation's criminal conduct on being prosecuted and convicted. Organisations will need to assess a multitude of factors in order to evaluate the implication of the self-disclosure. Questions arising might range from, will an invitation to negotiate a DPA be offered? What is the likely impact on the reputation? Importantly, what are potential outcomes of self-reporting? And also perhaps questions around legal professional privilege might be negotiated with the prosecutor. The answers to such questions will be found in the facts of the case, as each case will have very different and distinct facts to consider, including how any individual miscreants should be dealt with. Although there is no real practice experience currently, an invitation from a prosecutor might likely result following a complete disclosure to the prosecutor, providing full cooperation, a willingness to pay a fine or compensation, and undertaking remediation for the future. I know from previous experience as Chief Investigator of the SFO and having led the DPA development discussions that the road for any corporate DPA negotiation will not be comfortable. It will need to address front on some very significant facts and make them known to the prosecutors. The negotiations will be fact-based and agreed facts will be put to the court for a decision. There should be no surprises expected from either party, and the court will expect the corporate to accept the criminal charge on the understanding through negotiation that the prosecutor will defer the proceedings. An admission of guilt is not required, but the DPA, for the purposes of sentencing, will be treated as a guilty plea. In my experience, any invitation to negotiate a DPA should be managed through open and clearly defined discussions. This, after all, is what the judge will require when considering whether the DPA satisfies the interests of justice. Now, turning to the next slide, if I may, we have seen very recently the increased involvement of overseas jurisdictions connected with UK criminal investigations. The exchange of information between law enforcement agencies has been active both formally through mutual legal assistance treaties and through the informal channels. This process has increased over recent times as around the globe, especially in the UK and in India, law enforcement agencies get to grips with investigating economic crimes and allegations against corporates. This increase in information sharing is evident through the media reports around how the UK and Indian authorities, for instance, are liaising in specific criminal investigations within the various sectors ranging from the pharmaceutical to the engineering sectors, and is likely and will become commonplace in DPA casework. In multi-jurisdictional casework, the question of jurisdictional primacy will be a matter that will be addressed and considered in any UK DPA negotiations, and it is important that corporates are fully aware and understand how different jurisdictions will want to pursue information obtained. Gagan will now outline some relevant case issues connected with Indian investigations and the associated risk areas. Gagan.
Thanks, Keith. I think from an India perspective, we are seeing, especially for listed companies, the stock market regulators started taking a very strong view on books and records violation. I think, because a bribery case would, either if there's a falsification of books and accounts, it's actually a big problem for the stock market regulators now, and we see more and more attention coming up. The Ministry of Corporate Affairs and the Serious Frauds Investigation Office in India are also looking at cases of falsification of books more and more closely, so we do expect to see more enforcement there. Two other things I'd like to mention. One was a case a couple of years back where the Central Bureau of Investigation in India sent suo motu notices to about 40+ companies asking them why they should not be prosecuted in India for bribery and corruption charges, because their parent companies outside India had settled with regulators on accounts of bribery and corruption. I think that was the first time where people in India were like a little concerned now that actions of parent companies abroad could see consequential action by the government of India. And I think we've also seen, at least in 6 cases in the last 2 years, the Central Bureau of Investigation, again, writing to their counterparts in other countries, asking them for information on individuals, on bank accounts, and also at times asking for interview access. So clearly the whole, the cooperation between Indian agencies and agencies outside India, the increasing prosecution, especially from a stock market regulator perspective, the interest that they have in books and records. So it's really going up. The level of interest of regulators in India is going up, and we do expect to see a fair amount of action in this space in the coming years. I would now like to turn over to my colleague Rahul, and if you could move to the next slide, Rahul will talk a bit more about the regulatory framework in India.
Thanks, Evan. The existing regulatory framework in India, when we talk about the anti-corruption laws specific in India, they're based upon the colonial laws while India was under the British regime. And in fact, when it comes to the actual anti-corruption framework, it is pretty stringent in India. The problem is when it comes to actual enforcement, that is pretty low. And also, all current laws are focused on the public sector side, and at present, there are no legal provisions to check for graft in the private sector in India. Taking Prevention of Corruption Act, for instance, which was originally enacted in 1947, in 1988 it was amended, which brought all the anti-corruption laws within one statute. It was enacted to combat corruption in government agencies and public sector businesses in India. In fact, the much talked about telecom 2G spectrum scam in India, the people involved were booked under this act. Very recently, this year itself, the Lokpal Lok Ayukta Act was framed after the much publicized Anna Hazare movement, which seeks to provide for establishment of an independent ombudsman, or called the Lokpal, to inquire into allegations of corruption against public functionaries. An interesting development which has happened is the new Companies Act of 2013, which has been enacted with a view of aligning corporate governance in India with the global standards, and the new law prescribes higher standards of governance and encourages transparency and disclosure. While the word bribery and corruption has specifically not been mentioned in the new act, but it is the first time that the word fraud has been defined, and it has a very wide scope and ramifications on directors and officers of the company. It contains provisions to regulate frauds by corporations, including penalties, giving more powers to the Serious Fraud Investigations Office, which is similar to the SFO in the UK, which can in fact suo motu start investigations if they find the financial affairs of the company to be improper. Coming on to the proposed laws, there have been very interesting developments here, and there are about 6 crucial anti-corruption bills which are due for consideration. And these developments, they basically seek to fill gaps in the statute to bring it in line with the current international legislation, such as the UK Bribery Act. So, for instance, we talk about the Prevention of Corruption Act Amendment Bill 2013. It makes specific provisions relating to giving a bribe to a public servant and giving a bribe by a commercial organization. So there clearly we see a shift which is moving towards the private side of things. The Whistleblower Protection Act of 2011, which has actually received an assent of the President this May. The act has not come into force till now. It encourages people to disclose information about corruption and provides for a mechanism to protect identity of whistleblowers. The IPC Amendment Bill will actually make it a criminal offense to make giving and taking bribes in private sector dealings. So, like I mentioned, that at present there are no specific frameworks to check for corruption in the private sector, but government has definitely proposed amendments in the existing acts and certain new bills for checking corruption here, because big ticket corruption is really witnessed in large commercial or corporate entities. Moving on to the next slide. In the last few decades, India has witnessed instances of large magnitudes of bribery, which has certainly caused a deficit in business sentiment for a while. In fact, it may not be wrong to say that it was one of the key reasons that a new party was elected in the Lok Sabha and the general elections in India this year, as citizens were fed up with various scams such as the Commonwealth Games corruption or the telecom, or Colgate, and various other scams we talk about. And there have been significant efforts against corruption in India in the last couple of years. With evolving regulatory requirements, focus on key sector growth, and in the need to attract FDI, India has definitely strengthened its stand to fight this menace and taken a zero-tolerance approach towards bribery and corruption. There are numerous key initiatives which have been taken. For instance, the Government of India has launched enacted the Right to Information Act, in which the citizens can actually request for information from any public authority, which is required to reply expeditiously or within a period of 30 days on any government office-related aspects. The government is also moving towards the e-way side of services, where they want to make everything available on the electronic media to the general citizens, thereby eliminating touts and middlemen, and to create more efficiency and transparency. There have been significant efforts on the public procurement side, where we are moving towards e-procurement for contracts, which targets to achieve efficiencies and cost savings, and definitely improve transparency in procurement services. The defense procurement policy, which is a step in a right direction, and actually very maligned sector, or considered to be a maligned sector, the country has banned middlemen and agents and all the defense deals in this effort. The public procurement bill, which is yet to be passed, seeks to regulate and ensure transparency in procurement by the central government and its entities. The bill actually penalizes both acceptance of a bribe by a public servant as well as offering of a bribe in the process of procurement by the bidder with imprisonment and fine. There have been other initiatives which have been taken as well on the non-government NGO side, such as by the Transparency International, which does the integrity, the Corruption Perception Index, and has launched the Integrity Pact. Close to 50 public sector undertakings in India have signed up to this Integrity Pact. Another NGO called the Fifth Pillar, they introduced 0 rupee notes in various vernacular languages in respective states to be given as a bribe to bribe seeker as a non-violent and non-cooperation movement against corruption. There were desks which are put up in schools, colleges, marriage halls to just create awareness among students and children. Janagra, another not-for-profit organization, they have launched a website called ipayedabribe.com, which is a very interesting effort to tackle corruption by harnessing collective energies of the citizens, where general citizens can report nature, numbers, patterns, types of bribes on this website. It has been launched in over 700 cities, has got over 28,000 reports, and over a consolidated value of over $30 million of bribes have been reported. So there have certainly been very remarkable and fascinating efforts that have been launched, and I'm sure more will come and gain momentum. However, at an organizational level, the companies will need to take visible and actionable measures and steps towards addressing this challenge, or what we call the adequate procedures. With this, I will hand it over to my colleagues in the UK who can give you some practical insights to mitigate this risk.
Thank you very much. Thank you very much, Rahul. And yes, so coming back to the UK, we're going to have a look a little bit at the sort of the framework, the principles around adequate procedures. I should say that whilst it is somewhat Bribery Act focused, in our view, these principles are universal and are of value to anybody, anywhere, who is considering how they might effectively counter the risk of bribery in their business. So we focus here a little bit on the guidance issued by the Ministry of Justice, which it was required to issue under the terms of the Bribery Act, where they've identified 6 principles, and I shall go into each of those briefly in a moment. But I would start with the opening proposition that absolutely fundamental to the effective mitigation of bribery risk in any business is a proper understanding of what those risks are and how they manifest themselves in that business. And therefore, diagnosing bribery risk in a particular business in light of what it does, where it does it, and with whom it does it is absolutely fundamental. And therefore, you might think it's somewhat strange that risk assessment comes out at principle number 3 rather than principle number 1 in the Ministry of Justice guidance. However, ours not the reason why. In any event, practically speaking, it's fundamental that businesses take a careful look at what it is that they are doing and how they are doing it in order to understand how those activities, how those relationships, how those transactions might expose them to bribery risk in all its manifestations. And that is something that businesses are starting to do in a rather more focused and comprehensive way, but historically was not something that was done very well, if at all. And even now, one sees many businesses who have, in many respects, perfectly good risk registers, but where, if it appears at all, then bribery risk is one line item of many. And what we don't see always behind that is a more detailed and comprehensive review of, well, what is it that we are actually doing that might expose us to bribery risk, and how might bribery risk actually occur in our business. So there's a need to take a step back and look at the business with a fresh eye. That need, not only as you know, in terms of the basic principles of good risk management, but also because if you are following the UK Ministry of Justice guidance, then you know, you are, what it is advising is that one institutes proportionate procedures. Well, the very essence of proportionality is that it is risk-based. So again, that reinforces the importance of understanding risk. On top of that, we then have the concept of top-level commitment, tone from the top, if you will. That is also crucial, getting the right culture in an organisation, making people believe that the policies that you have are, are meant to be implemented, that one has the full support of management in doing so, and perhaps that in difficult circumstances where there are difficult decisions to be made, but businesses may actually take tough decisions, may actually walk away from opportunities if they can't get comfortable that business can be done in a way that is safe from corruption. And that is a very, very big conversation and a very big challenge for many businesses operating particularly in higher risk parts of the world. Another key element is due diligence. This relates both to the risk that somebody might do something on your behalf, so an associated person in the language of the Act, Bribery Act, might do something on your behalf that is corrupt, and that the liability for that would spring back onto you as the principal. It also, of course, encourages people to think carefully about when they are buying a company or a business. In other words, they're doing some kind of a corporate transaction or a merger, that they think carefully about what it is they're onboarding. And so due diligence should extend also to consideration of risks in the context of corporate transactions, as well as day-to-day business transactions. It really is crucial, though, that in the context of the use of agents, distributors, any intermediary that acts on your behalf, care is taken on a risk-based approach. And in that context, what needs to be considered is both the inherent risk of the activity that is being outsourced, and then, of course, the risk associated with the party to whom that activity is being outsourced. The due diligence is done on the third party, but the level of due diligence is guided by the inherent risk of the activity that underlies that relationship. Communication and training are also crucial to communicate messages about policies and procedures and values and ethical standards within an organisation and outside it. Communication with parties such as customers and suppliers is also an important feature. Training on policies, on how to go about avoiding risk, how to assess risk, are also critical for employees and other relevant third parties. And then there again, a risk-based approach is appropriate. It may be important to train certain people more intensively, perhaps in a more direct way than others, based on their propensity to create risk for your organisation. And last but not least, monitoring and review is absolutely critical in terms of understanding how effective your program is. The guidance is very clear that adequate procedures doesn't just mean that you have policies and procedures that look good on paper. They actually have to be operating effectively, normally speaking. And therefore, the question for management will be, how do you know that they are operating? So what assurance you have around that is a crucial issue in terms of monitoring compliance with ethical standards and policies and procedures, and also monitoring high-risk activities on a real-time basis, understanding where you are at risk and how those risks are developing in the business. But it all comes back ultimately to risk and the crucial importance of keeping that risk assessment fresh and alive within the business. It's not just a once-only process, but an ongoing process to reflect changes and developments in the business. So with those sort of general principles outlined, I'd like to give the last word back to our Indian colleagues, and Gagan perhaps firstly around what adequate procedures might need to look like in an Indian context.
Thanks, Will. I started by saying that India is a land of contradiction, and I'll end by saying the same. If you pick up the news in India today, the top news is, on one hand, the success of India's Mars orbiter mission, the maiden attempt, and it's in the orbit of Mars. And the other news is one of the leading lawyers arrested in connection with money laundering related to a bribery charge. So clearly a land of contradictions. I think what Will said holds very good, very well in terms of practical insights. And can we also move to the last slide, please, slide 13, while we are at it. I think Will made some excellent points. All of them are very, very relevant to India, and I cannot emphasize more the importance of doing adequate due diligence or having a fully functioning compliance program in place. The only last point I'd like to make is, do not succumb to pressure when you do business in India. It is very likely that you may be propositioned or solicited for a bribe in relation to doing business in the country or doing business with Indian entities. But it's very important that companies do not succumb to this pressure. I think it sets a very bad precedent, and clearly that should not be there. Use professional help as needed if such situations come up. There are enough recourses in place in India. At least in the last 2 months itself, we worked with 3 companies in going back and filing cases with relevant departments against officials who proposition companies for bribes. So there are newer and newer ways in India where you can go back and you can report these instances back, and it's not always necessary to make a payment and move ahead. So with that, I turn it back to the moderators for the Q&A session, and thank you very much for your participation today.
Thank you very much to all our speakers for that very insightful presentation, and all our colleagues at PwC. The audience have been sending us some questions, so I will be reading them out for you to our colleagues. So I think this one would be probably for Gagan or Will. We're getting a few questions actually on the issue of agents and intermediaries. The risk in India, is this a phenomenon that manifests itself in a particular way in India? Is this common practice for companies to expect to have a consultant or a middleman type of figure to negotiate on their behalf? And does this fall under the Bribery Act?
Perhaps if I start from a UK perspective in terms of the last part of that question, and then Gagan can talk about, as it were, the practices in India itself. So just to be very clear, the use of any kind of intermediary, such as a consultant or middleman, in dealing with government officials in India or indeed anywhere else, is very much falls within the definition of an associated person under the Bribery Act. So if such an intermediary were to engage in any kind of corrupt behavior on behalf of a company who had engaged that intermediary to interact on its behalf with government officials or indeed anybody, but certainly government officials in particular, then that would render the company who had engaged such an intermediary potentially liable under the Bribery Act. That is, as I say, seems to me that falls squarely within the definition of an associated person and would engage the Section 7 offence of failure to prevent bribery. So there's a big risk for corporates, and they need to think very carefully about what it is they're outsourcing to third parties, and that's really where the crucial importance of appropriate due diligence and appropriate contractual terms and other checks and balances on what third parties do on behalf of a corporate really come into play. So those are the principles, and hopefully that's a clear explanation of how that interacts with the UK Bribery Act. I'll hand over now to Gagan, perhaps just to tell us a little bit more about the reality in India of the use of such intermediaries.
Thanks. Well, I agree. This is probably the single biggest risk we see in India. A lot of companies, when they are in situations where they want to pay bribes, they use intermediaries. But this is also one of the main areas that's coming under a lot of scrutiny, and that's why it's very important, as Will mentioned, to have proper contracts, proper scope of works, doing adequate background checks on third parties and agents, and really in deciding how and what their effort is, and whether the fee that they are paid is commensurate with the effort they're putting in. So for example, we've seen a government fee maybe just like a pound or something, and the agent gets paid 50,000 pounds to get an approval, which is clearly quite inconsistent at times with the effort that one is required to put into getting stuff like that. So really an area which is very much in focus, and something which we see the agencies in India very, very interested in at the moment.
Thank you for that. Another question is, how can we make our existing framework compliant for both the UK and India markets?
So if I've understood the question, that's I mean, how one creates an anti-bribery program that is, as it were, compliant in both jurisdictions. Well, I think the general answer to that question, and this is a common challenge for organisations. Any organisation operating internationally is going to find itself subject to more than one set of laws. So a UK company doing business in India, for example, will be subject to the UK Bribery Act, and of course will also be subject to the local laws of India, in which it is operating, at least part of its business. So you have to have regard to both regimes, and I suppose the obvious way of approaching that is to ensure that whichever regime is more stringent in a particular aspect is what you use to determine the scale and scope of your anti-bribery controls in relation to that particular aspect. To give you an example, there may, in certain jurisdictions, be very strict limits about the value of a gift or an item of entertainment that one is allowed to offer to a third party, particularly a government official. In some countries that limit is actually zero. In other countries it is some amount. In other countries, again, it may not be defined. So if there is a defined limit, then you must make sure that your policies and your procedures will be tailored to making sure that you stick within that limit. If it isn't then defined, then certainly the UK Bribery Act and Ministry of Justice guidance approach to that would be a bit more pragmatic. It would say, okay, well, you need to make sure that whatever the level of expenditure is, that is not and could not be construed as being a bribe, that it is simply there to help oil the wheels of business in a normal and legitimate way. So yes, this is something that has to be very carefully thought through. I have to say, I think in many respects, when one looks at anti-bribery regimes around the world, they have more in common than they have that distinguishes them. But nonetheless, there are, you need to be aware of the possibility that there will be very specific rules around certain aspects of doing business in a particular jurisdiction that you need to make sure are properly built into your program. Again, perhaps I might offer up the microphone to my Indian colleagues just to add anything they want to on, again, the practices in India, whether there are any other particular examples of detailed laws and regulations that might not be so well known to the UK audience.
So I think, Will, you appropriately summed it up. The difference is not so much in the laws. I think the premise of both the laws is you cannot bribe, fairly consistent there. And the only tweaks we see in companies coming up and applying their frameworks in India is to slightly customize this to the cultural aspects, especially on policies like gifts, entertainment, travel, and really dealing with government officers like that. However, the area of concern always remains third parties. We found more and more companies working very, very hard to put effective compliance mechanisms in place for third parties. So that's, I suspect that one degree of customization any plan would need is to really add third-party compliance into your bribery and anti-bribery and corruption programs.
Thank you very much. I have a question for Gagan, and that's on whether the public procurement bill, will it be made applicable by states?
I'm sorry, Rena, can you repeat the question, please? Couldn't hear you very well.
Sorry, just repeating the question. It's on the public procurement bill. Will that be made applicable by state as well as federal?
I think it would really depend on what policies, the states come up and the federal government comes up with. There are certain federal government funded projects and certain state level funded projects. I think it's still, because of the way the federal and the state structure that we have, and that, put with the added complexities of having certain authorities which directly deal with industries coming under their perspective. I think I personally don't see a whole degree of connectivity coming through it across the channel. I think it will really depend a lot from the PPP policies that come up by individual departments and government agencies. I think I certainly don't see at least something coming out of central level that will apply consistently to everyone throughout.
Thank you. Another question, and this will be for panelists on both UK and India. That is, what is PwC's take on the future of anti-corruption in India, given India's reputation in this area?
I can probably start and then maybe Will can jump in. I personally think, and things will get better in India. I think clearly there is a level of frustration that businesses have today with the corruption practices that we have and the level of corruption that is there in the country. And it's not just businesses. I think the average person in the street is also quite tired of endlessly being asked for money for getting things done routinely. That coupled with some strong messages coming from the government on easing up policy reform, on making things accessible to people and making information accessible to people. I think these are all steps in the right direction. I don't think corruption is a problem that will get rooted out in the next 5 years. It will take maybe a time period longer than that. But I think especially starting with the corporates, easier regimes and ease to do business, add to that a strong regulatory environment as a deterrent. I think these will be steps in the right direction, which will, at least I'm very hopeful in the next couple of years, start driving corruption down in this country. It will be a long haul, but I think these are definitely, we see steps being made in the right direction to bring the level of corruption down.
Yeah, I mean, I would definitely echo that. I think you only have to look at how far India and other of the major sort of developing economies has come, and the direction and the momentum of travel are clearly very positive. And I think what comes with that is an increasing focus on standards of good governance generally, in particular, anti-corruption, because corruption acts as such a brake on successful economic and social development, that countries are really being forced to confront it. Of course, many countries are in very different places in that regard at the moment. I think all the legal and regulatory developments that we've heard outlined this morning point in that direction. And of course, there is support from the international community as well. And I think the UK Bribery Act can be seen as another piece in a much larger jigsaw puzzle. The common theme being that many jurisdictions now are seeking to take responsibility for the actions of their corporate citizens, not only domestically but internationally. And I think India is part of that pattern. And it will take time. Nobody pretends this is going to happen overnight, but it's too important and too critical to the long-term success of major economies like India for it not for things not to improve steadily over time.
Thank you for that. Now, if I can just send you one final question, because unfortunately we're running out of time, but this question, it comes in two parts, and it has to do with the issue of agents and consultants, which appears to be a big area of concern here for UK companies. The question is, would a written contract between a UK principal and their agent that explicitly excludes the solicitation of facilitation payments, would this be a robust approach for a UK company to protect themselves in view of the Act? And the second part to this question is this mention of consultants only applied to the UK Bribery Act, or is it also covered in other international legislations such as the US and the EU?
Perhaps if I start on that, and again my Indian colleagues will have a view. So in terms of the UK Bribery Act specifically, clearly having appropriate contractual terms which give you the right to terminate for cause if they do something corrupt in the way that's been described in the question, that is helpful. I think it is it is an important element of one's risk mitigation around the use of third parties, but I don't think anyone should kid themselves that is necessarily a panacea. You could put an anti-corruption clause into your third-party contract, but if you don't, as it were, reinforce that through your whole behaviour in that relationship, if you don't also take reasonable steps to monitor the activities, to understand what the money you're paying to that third party is actually being used for, if you don't do appropriate due diligence on that third party to understand how likely they are to put you at risk, if you haven't done a proper risk assessment on the inherent risks of the activity you're outsourcing to that third party in the first place, and so on and so forth, then it's simply relying on some contractual term, it seems to me, looks a little thin. So yes, it is an important element. It's certainly something we would encourage people to do. Other contract terms that one might want to think about as well might include trying to insert a right of audit into the contract, so that you not only have the right to terminate if you find evidence of inappropriate behaviour, which you certainly want to have as a right, but also you might want to think about having a right to actually take proactive steps to review what that third party is doing for you and with the money that you pay to it. There are practical challenges with all of these things, of course, but I think that the best approach is to do what you can across all the areas of possible risk mitigation, and not only to rely on one element of it. I don't know whether Gagan or Rahul have any thoughts that they would like to add from an Indian perspective on that, or indeed what practices they see in India around that important question.
Sure. Well, I can actually just quickly give a practical example. One of the cases that is being prosecuted right now was a contract written out with a third-party agent saying you're going to get us a license and we're going to pay you £10,000. But however, if you get us a license within 15 days, we'll give you £16,000. So really the question was, when the government did not have a fast process, what was this additional £6,000 for? And this is one of the cases that is being prosecuted. And there are a number like this. So I think it's how the contract is written, what is really the intent of engaging the third party, what is really in the third party scope of work, and is the fee commensurate with the work being done by third party. I think these are very important yardsticks one needs to consider, because God forbid should things go wrong, these are exactly the things that will be put under a microscope, and every act would be examined as to how really the contract and the scope of work and the resultant fees were paid for third party contracts.
Thank you. And I think just coming on briefly to the second part of the question, which was whether other legislation around the world also encompasses the acts of intermediaries. I think a clear answer to that in general terms is absolutely yes. So because it's such an obvious, as it were, loophole if laws did not cover that, you could simply outsource bribes to third parties. Now, no intelligent law is going to allow that, and indeed, most of the major international conventions and the laws that are responsive to that, I think, do encompass acts of third parties. Just to take one example, the US Foreign Corrupt Practices Act that people may well be familiar with. If you look at many of the cases that have been investigated and prosecuted or involved or resulted in settlements with the US authorities in relation to violations of the FCPA, I would have thought the majority of those involve some element of third-party action. So it's certainly a feature of the content and the enforcement of the FCPA, and I think it's fair to say that it's probably, if not universal, then overwhelmingly prevalent in other laws around the world. Gagan, perhaps you'd like to comment in terms of the Indian law specifically. I mean, I assume that would apply to Indian anti-corruption law as it does to many others.
That is correct. That's correct, ma'am.
Well, thank you very much to our speakers for all those insightful answers on the questions. Unfortunately, we've run out of time, but rest assured to all our attendees that all the questions that have been answered, they will be responded to after the webinar. Now, thank you very much, everybody, for your time. I hope the webinar was valuable to you. And if you do have any feedback or comments about today's session or any session that you would like to see us do in the future, please do feel free to get in touch. We're open to your suggestions. So thank you very much for joining us today.